Hey, how's it going? It's attorney Vincent Hughes and welcome to the channel. Today I'm going to provide you with a comprehensive guide on the California Department of Motor Vehicles Administrative Per Se license suspension. In this video, I'm going to walk you through the details of the APS process and provide you with all the essential information you need to know. Whether you're facing the possibility of having your license suspended or if you just want to be informed, this video is for you. So let's dive right in. So what exactly is the California DMV Administrative Per Se license suspension? Well, it's a legal action that's taken against individuals who are arrested for driving under the influence of alcohol, drugs, or both. This takes place before the court even knows that you've been arrested. So even before any court dates, arraignments, anything like that, your driving privileges are already at risk of being suspended for up to 4 months. This process is completely separate from any criminal charges or the criminal process, and it is administered solely by the DMV. So let's understand how this process works. The first step is your arrest. When you're arrested for DUI, law enforcement will confiscate your physical driver's license, and they'll issue you a pink piece of paper, which is a temporary license valid for 30 days. Following your arrest, the DMV will initiate the APS process by issuing you a notice of suspension. This notice informs you that your driving privileges will be suspended within 30 days unless you request a hearing. You must do so within 10 days. So to contest the suspension, you must request a hearing with the DMV within, what did I just say? 10 days of receiving that notice of suspension or the date of your arrest. This is a very crucial deadline because if you fail to meet it, you automatically will have your license suspended for 4 months. It's important that you note that once that 10-day period is gone, you can't ask for a hearing any longer. It's not 11 days, it's not 12 days, it's 10. So what is the hearing? The hearing is a formal proceeding where you can present your case and challenge the suspension. It's highly recommended that you seek quality legal representation to navigate this very frustrating and complex process efficiently. At the hearing, there will be 3 main issues that have to be determined. They're determined by a DMV hearing officer, not a judge, an employee of the DMV with the title of hearing officer. So the first thing that must be determined is whether the driver was lawfully contacted and if the arresting officer had probable cause to believe that the defendant was driving under the influence of alcohol, drugs, or both. Second, it must be determined whether the driver was lawfully detained or arrested. Third and finally, must be determined whether the driver was operating a motor vehicle with a blood alcohol concentration that exceeded the legal limit. After considering all of the evidence presented at the hearing officer will make a decision regarding the suspension. This generally does not take place on the date of the hearing. You'll receive a notice in the mail roughly 7 to 10 days after the hearing, and it'll tell you what action the DMV is going to take on your driving privileges, if any. If the suspension's upheld, your driving privileges will be suspended for approximately 4 months. Now let's address some of the common questions about the California DMV APS license suspension. Question number 1, can you continue to drive if your license is suspended under APS? No. Once your license is suspended under APS, you no longer are permitted to drive until the suspension period is over. It's crucial that you comply with this suspension to avoid any further legal consequences, including separate misdemeanor charges for driving on a suspended license. Question number 2, is it possible to obtain a restricted license during the suspension period? Yes. In many cases, individuals may be eligible for a restricted driver's license during the suspension period. This allows you to drive under certain circumstances, such as for work-related purposes, attending court order treatment programs, or other limited scopes that the DMV will outline for you. Another option is that you can voluntarily install an ignition interlock device, also known as a breathalyzer, for that 4-month period, and you can drive where you want, when you want, as long as it is installed in your vehicle or any vehicle you may drive during that period. Question number 3, what happens if you refuse to take a chemical test during a DUI arrest? Well, in California, refusing to submit to a chemical test can result in very severe consequences, including a license suspension for up to a full year. Additionally, the DMV may impose other penalties and requirements, such as mandatory completion of a DUI education program prior to any kind of reinstatement or restricted license. Question number 4, can you appeal the decision of the APS hearing? Yeah, if you're dissatisfied with the outcome of the hearing, you have the right to appeal the decision. Make sure that you understand, though, that there are very specific requirements and deadlines for filing an appeal to ensure that your case is considered by the DMV and/or the courts. Question number 5, will the APS suspension affect your criminal case? Well, the APS process, like I said earlier, is completely separate from any kind of criminal charges relating to your DUI arrest. It's essential, though, that you contact a DUI attorney who focuses on representation in DUI-specific cases to best understand how the APS suspension may intersect with the criminal proceedings. Question number 6, can you reinstate your driver's license after the suspension period? Yeah, once the suspension period is over, you can apply to reinstate your driving privileges. The process usually involves paying a reinstatement fee and providing proof of insurance. You need to contact the DMV's Mandatory Actions Unit for any other specific requirements or processes that you must successfully navigate in order to reinstate your driving privileges. So to sum it all up, navigating the California DMV APS process can be very complex. Remember, understanding the steps involved, requesting a hearing, the deadlines associated, and just getting your particular case handled in a way that's best for you is best served by getting skilled legal representation. Make sure you consult with an attorney who provides guidance in these DUI specific cases so you can put together a personalized game plan on how to best proceed with your case. My office has extensive experience in handling both APS hearings and representing those in criminal court that are accused of DUI. I provide very personal attention to your case, and I make sure you get the representation you require and that you deserve. Contact my office, schedule a free consultation. Let's discuss the best course of action for your case. Remember, securing a diligent and zealous defense is critical, especially when you're facing DUI charges in California. So if you found today's video helpful, if you found it educational, do me a favor, hit that like and subscribe button down below. My office is focused on providing additional content like this each and every week from here on. I want to make sure you're educated in your rights and how to navigate the criminal justice process and procedures. Never forget, when accused, call Hughes. I'm here to help, and I look forward to seeing you next week.